again, I hope you all had a nice summer. And although the summer is coming to a close and ending, Turkey KKDIK is just about to kick into gear, or already has if you ask. Today, first webinar of the season after summer, and the topic today will be Turkey KKDIK, and indeed the registrations are proceeding, and we'll look at these procedures and principles on the KKDIK implementation, which was published, was it last week on the 12th of August. So today we will have two presenters, Sibel Kilic and myself. I'm Frederik Johanson. I'm a partner, head of sales here at REACHLaw, chemical engineering by background. I've been working for a long time with REACH and REACH-like chemical regulations, and now, of course, a lot with the Turkey KKDIK. And Sibel, over to you, please.
Hello, my name is Sibel Kilic. I'm the director at REACHLaw Turkey, based in Istanbul, and lead the team here. As my background, I'm a chemist and I hold a PhD in organic chemistry. And I have been working with REACH regulations since 2013 and with the KKDIK regulations since it was introduced in Turkey in 2017. Thank you, and I wish you a good webinar session, and I will leave the floor to Frederik till the Q&A part. Thank you.
Thank you, Sibel. And indeed, you will have to bear with me until the Q&A part when we get Sibel back online. She's very busy now, as you can imagine, so I will take the bulk of the presentation. So looking at the agenda today, you will get a quick introduction to REACHLaw. Then we will also get a brief overview of the Turkey KKDIK regulation, just the ins and outs, the basics, and some statistics, updated statistics. Then we will dive headfirst into these procedures and principles and look at what they mean in detail. We will not go through all of those because there were also other, let's say, articles in these procedures and principles that are not so interesting at this point in time. So we will focus on the most interesting bits and look at those in detail. Then we'll also look at some pointers of what it means for the industry and what actions to take now, ASAP. We'll have some conclusions before then going to the Q&A at the end. So as you probably are suspecting already, this will take a bit longer than 60 minutes. But for those of you who have to leave, you can always watch the recording later on YouTube. So indeed, REACHLaw in brief. Who are we? What do we do? What's our focus? And where are we located? So indeed, we are providing support for REACH and REACH-like chemical regulations, but now also product-related regulation to some degree. So we have offices in all of these locations where you have these REACH-like chemical regulations. Of course, Turkey office there being in Istanbul, of course. I'm calling in from the head office here in Helsinki, Finland, where we deal with, of course, EU REACH for the most part. But we also have a new office established in Ukraine, in Kyiv, for Ukraine REACH purposes, which is the newest newcomer into the REACHLaw family. Then we also have office for UK REACH purposes in Manchester, in the UK, and in Seoul, in South Korea, for K-REACH, K-OSHA purposes, and also in India for India BIS related topics. We will not talk about that today. And in India actually is growing quite a lot, so we have now two offices, one in Delhi and the other one in Mumbai in India. So indeed, we have, if you could call it a three-legged stool, we work with compliance pertaining to chemical regulations. So obviously all these REACH-like chemical regulations globally, as of which Turkey KKDIK will be the topic today. We also work with pertaining to this compliance part of our activities with the India BIS license when it comes to these product compliance services. PC and ESPR skip to some level also. We do some advocacy work also for clients. For example, working with impact assessments and engaging with stakeholders as part of the advocacy purpose, and providing technical support as part of these advocacy services. And then we have our final leg, if you will, of these foundations of our services, which is sustainability, where we provide them services pertaining to breach revision, SVHCs, and circular economy to a certain level. But by far, the compliance part of our business is the biggest, and that will be the topic of today, and more specifically, of course, Turkey KKDIK and the pre-registration and registration process. So pertaining to Turkey-related services, these are what you see on the screen now. We provide a full set of services. We are a big only representative in Turkey, through which we can provide all the necessary technical services, but also directly to companies who do not need our services in OR. We take care of pre-registration, co-registration, and this provisional registrations there, of which we will be talking about today. We do lead registrations, consortia management, joint registration management, everything pertaining to KKDIK and SEA compliance. We also do SDSs, of course, and are able to sign off as a KDU, so certify these safety data sheets, as well as dossiers when need be, and much more. So we are indeed one of the leading only representative services providers globally, and we service all of these REACH-like chemical regulations that we have in place, or the major ones, let's put it this way, that are in place currently. As of which one, a big one is, of course, Turkey KKDIK. So indeed, REACHLaw, we specialize in these chemical regulatory topics and compliance thereof, and advocacy and sustainability. But today, as I said, chemical regulatory compliance will be the topic, and specifically Turkey KKDIK. And the usual disclaimer, copyright. So of course, the content in this webinar presentation is for general purposes only. So if you need to consult for specific issues, topics, please solicit us directly for professional advice. So we don't accept any responsibilities for what we are showing here in this webinar today, etc. You can read the disclaimer on the screen, so that satisfies the lawyers in our company. Okay, so let's dive into the KKDIK regulation, and I'll give you a quick overview thereof. So those of you who are well familiar, already know this, you can tune off for a few minutes. And then, just to save a bit of bandwidth for our colleagues around the world, I'll just turn off my camera. You will not see this on YouTube, of course. Anyway, KKDIK is very similar to the EU REACH regulation, and it has already been enforced since 2017. It has these similar type of transitional provisions, which we will talk about today. They have been clarified with this procedures and principles document that was published on the 12th of August. The competent authority is the Ministry of Environment, Urbanization and Climate Change. You will see this abbreviation littered in this webinar presentation, so MOEUCC. I will just call it the ministry or authorities in this presentation. So indeed, it's a massive legislation, as is the EU REACH, which is essentially based on to a very high degree. And it also stipulates requirements, basic market access requirements for substances that are manufactured in Turkey or imported into Turkey at 1 ton or more per year. And these need to be pre-registered and registered by the applicable deadlines. We'll talk about this. And one of the prevailing articles is this no data, no market. What it essentially means, same as under EU REACH, is that if you don't provide data for your substances, you will not have a market. And providing data includes also pre-registration and not just the registration part. It's estimated that the KKDIK regulation is going to affect more than 10,000 companies globally. So not just Turkish-based companies, but companies supplying to Turkey their chemicals, and therefore these chemicals need to be, as substances more specifically, need to be compliant with these KKDIK requirements, either through the importer or only representatives as appointed. So, as with e-REACH, all substances, unless specifically exempted either from the registration requirement itself or the regulation as a whole, then means that they are within the scope of this KKDIK regulation. So I said I'm going through this very quickly. So I said substances manufactured, imported at 1 ton or more into Turkey or in Turkey need to be pre-registered and registered. The registration tonnage bands, same as under e-REACH and many of the other REACH-like chemical regulations, is 1 to 10, 10 to 100, 100 to 1,000, and over 1,000 tons. And the data requirements increase and the costs related to registration increase the higher the tonnage band, unless you are in the situation where you have an intermediate at higher tonnage bands. In these cases, the costs are necessarily not increasing because the data requirements are less than for full substances. That being said, most substances registered are going to be full substances, so you have the full data requirements associated with the tonnage band. In some cases, as mentioned, you could also register as an intermediate, as an on-site isolated intermediate, or transported isolated intermediate, but these must be under strictly controlled conditions, and these conditions must apply through the whole supply chain to be able to benefit from these reduced data requirements for intermediates. And submissions of all documents, notifications, pre-registrations, registrations, etc., are done in Turkish language due to this chemical registration system called KKS. We'll talk about that briefly in a few slides coming. The deadlines, they were amended back in 2023 for registration, and you can see the latest or the current deadlines for different type of substances and tonnage bands on the screen. So for highest tonnage bands, over 1,000 tons, and then these very toxic to aquatic organisms, acute and chronic substances at 100 tons or more annually, or CMRs, category 1A and B at 1 ton or more will have the registration deadline of end of next year, 2026. For then to 100 to 1,000, and then for the lesser tonnage band, the deadlines will be less. So 100 to 1,000 tons per year will be 31st of December 2028, and then for 1 to 10, 10 to 100 will be December 31st, 2030. So that's a wee bit in the future already, but time flies, as we can see. So if you look at how much time we have left to register our substances in months, always interesting to see. The first deadline is in 16 months. The next one in end of 2028 is in 40 months, and the last end of December 2030 is 64 months away. So it sounds a lot, but these arrows were a lot longer last year. So time flies indeed, and especially for the first deadline, we are coming into critical territory where things need to start happening, as we will talk about in this presentation. Very important, of course, to understand that joint submission concept applies. So the one substance, one registration principle. It is possible to deviate, but you need to have specific permissions for that. The other option is to opt out from certain endpoints in the joint submission. Usually that's not needed, but in most cases you are having one lead registrant per substance, and you have 0 to many co-registrants as part of this joint submission. So what that means is that, for example, if there's just one company going to register a single substance, then that company needs to become the lead, because there are no other ones who are registering. So that's why it's 0 to many co-registrants. And these have to then be, of course, the registrations, including the joint submission. So the lead dossier needs to be submitted to the ministry, by these applicable deadlines we looked at. So if we look at the process just in quickly, going from pre-registration to registration. So first, of course, you need to pre-register your substance through the KKS system with the substance ID, and you provide additional details. I will not go into details here. Now, with this introduction of these procedures and principles, there is a deadline set for that. We'll talk about that. Once you are in this pre-see, if you have pre-registered your substance, you will be able to see essentially who else has pre-registered the substance, and you should cooperate together to define the substance identity, and then also select a lead registrant. And now we have also a deadline by end of this year for those cases. We'll talk about that. And eventually the lead registrant then prepares the joint registration dossier, the lead dossier, and also submits these provisional registrations, as well as, of course, the co-registrants does it themselves. We'll talk about this. And then the lead registrant issues letter of accesses to the co-registrant so that they can join the joint submission and submit their own registrations. And then you are done with the registration bit. Now you are part of the joint submission, both as a lead and as a co-registrant. So the registration fees were updated beginning of this year. So you can see that they were, like if you look at the Turkish lira, it was quite a significant update, but due to the inflation in Turkey, the changes in euro value is not that much, unfortunately, or fortunately, depending on whose side you are, so from whose point of view you are looking at this. But anyway, these are the updated fees. So you can see that the registration fees that you are paying to the ministry are significantly lower than what we have in the EU, for example. The KKS system is this chemical registration system that is in Turkish language, through which you would be then submitting the pre-registrations and the registrations, whether it be the lead or the co-registration dossier, but you also do a lot more P-port sale notifications, later on inquiries, etc. will be provided through or submitted through the system. And the KKS system is a hybrid system where it essentially combines EU REACH IT, IUCLID 6, and the KSR tool. And you have to have Turkish citizenship to be able to first of all create an account and then access this account. So you have to have these to be even able to see the account. So I myself, for example, cannot see this myself unless my colleagues in Turkey show it to me. And if you don't have an account now, just bear in mind that it can take up to 3 weeks to get activated by the ministry if they have to start from scratch. Some registration statistics, slightly updated. At the moment, there have been estimates of more than 250,000 pre-registrations being submitted till date, maybe even much more than this. As of yesterday, we had 3,373 nominated lead registrants. Out of these, they have submitted approximately 2,400 lead registrations, and this is still the same number as, for example, in our last presentation from a year ago, because it has still not been possible to submit new registrations through the KKS system because the submission has been disabled. Albeit we're looking to have that opened up for submissions within a couple of weeks. I'll talk about that a bit later on. The ministry is expecting over 15,000 different substances to be KKDIK registered. So you can see that there's quite a gap between 15,000 and 3,373 lead registrants, because one lead registrant is for one substance. So we'll see what the final number will be, but maybe it will be much less than this 15,000. Many lead registrants at the moment are only representatives, such as REACHLaw Turkey, and this is for the reason that many of these lead registrants for EU REACH are also opting out to be, or opting in, let's say, to be lead registrants under KKDIK in Turkey. And it's expected that a total number of KKDIK co-registrations by end of the registration deadlines in 2030 will be approximately 50,000. So 50,000 co-registrations are expected to be submitted by the last deadline. So which is a sizable number. What that then eventually turns out to be is something to be determined. And a quick last comparison table before looking into, or detail, let's say, diving into this detailed look at the procedures and principles. Just a quick comparison table. So you can see that pre-registration is the same that we had for EU REACH. Inquiry is the same, albeit it's not yet available. I'll talk about that in some slides briefly. Provisional registration, this is new. I will talk about this absolutely in a few slides. This is something we didn't have for under EU REACH, but we have in Turkey. Registration, of course, applies. Polymers, yes, but monomers require registration, same as under EU REACH, unless that is changed with this REACH revision, which, by the way, Turkey will likely follow then eventually. More data, more volume, more data is required. Joint registration is applicable. Only representatives are possible. PPOD R&D exemptions are possible. No products do not have to be notified themselves. Safety data sheets, the same requirements, except in Turkey they have to be certified by this KDU, this chemical assessment expert, while in the EU it's not required. And safety data sheet certification is of course something that we don't have in the EU. And the same with dossier certification. So essentially you have a KDU expert compile certain in certain cases the dossier and submit it to the authorities in Turkey through KKS. So let's dive into the crux, if you will, of this webinar, which is having a look at the procedures and principles in quite a lot of detail, as much detail as I guess is possible at this point in time. For some of these endpoints, we're not looking at all of them. But indeed, on August 12th, that's last week, yes, on Tuesday, the ministry published this final version of the procedures and principles for KKDIK implementation. And the point with this document is that it's aimed to clarify parts of the KKDIK registration process, and to be honest, add a bit of stuff into the process also. So you can follow this link, and you can go down at the bottom of this the announcement page to download this PDF that we are looking at today. Today we are looking at the English or translation of this information and consolidation of the information and processing of this information into a presentation format. So we'll not look at the document per se, but you can have a look at it directly yourself by downloading it. So and maybe just to add, so many of you have already seen these previous draft versions of this document. So this is now the final one that has been published, and this has now become law essentially, because it's a legal document based on this environmental law in Turkey, as well as the KKDIK regulation. So this is a legal document that has to be and must be followed, because as of the publication, it is now in force. And it looks at different topics in this document itself, and these are shown here in the middle of the presentation. So if you see this PMP, it means just the procedures and principles. So it refers to this document. So if you're wondering what that is, it's not pulp and paper. It is procedures and principles. So looking at the document, which is actually constitutes 8 pages, and including 2 annexes, but it contains the following. So it defines provides definitions, discusses the scope, the legal basis, etc. in Articles 1 to 5. We will not look at this because it's essentially these two slides we'll be looking at. But then it looks at pre-registration deadlines. This is Article 6, absolutely looking at that. One substance, one registration. We know that already. We will not focus on that. We discussed it briefly. We will definitely look at the selection of the lead registrants, which is under Article 8. Joint submission, this is really not that interesting here, not so much new information. Therefore, we are skipping ahead and we will cover this provisional registration discussed in Article 10. Completion of the registration process, not so interesting here. It essentially discusses what happens, what is considered a completion of the registration process, and what you should do if you are not able to, for example, get the data you need for being able to complete your registration process. You can apply for extension and so forth. But we're not looking at this because it's not so urgent at this point in time. And then it defines these chemical science group and advisory group that are supporting the authorities with this registration process and KKDIK in general. We look at some of the implementing provisions in brief, updating the registration dossiers under Article 15. Safety data sheets, we're not looking at that. It's not so interesting. The only thing that's essentially put into law, if you will, is that it's also included in the law that you have to submit your safety data sheets to the ministry online, and then of course certify these with this KDU. But we will not cover that because it's most of you are doing this anyway already. Inspection and administrative sanctions, will not look at that. It essentially says that they can fine you if you are not compliant and so forth. Then we'll talk, just highlight the entry into force, which we already know. It is in place, and we will skip enforcement for the time being. It's not very interesting. The same enforcement bodies apply to this as for KKDIK. So indeed, let's first have a look at this Article 6, the pre-registration deadlines. So indeed, now we have a fixed, firm, hard deadline for pre-registrations. So if you are having substances on the Turkish market already before this time, then by end of October, you will need to have those substances pre-registered, provided they are required to be registered, meaning they are within scope of registration and they are placed on the Turkish market at 1 ton or more. So this is a hard deadline. This is now something we were waiting for. Now we have it, and it's coming up in 72 days, end of October. However, if you were not on the market by this end of October deadline for this pre-registration, meaning you are placing a substance for the first time on the Turkish market after this 31st of October 2025, then you have to perform this pre-registration within 30 days. So this is now, as said, very firmly encoded in the legal text, and companies should absolutely make sure that you have registered, pre-registered all substances that you need to have pre-registered, and having do so by this 31st of October deadline. So if you are on the fences on some pre-registrations, now is the time to act and just go and do it, or then forever regret if that is the case, or not then place these substances on the Turkish market at 1 ton or more if they require the registration. So this is now very clearly black and white encoded in the legal text and already applies as mentioned. Now we'll look at the selection of the lead registrant, which is a slightly more complicated, more slides here, but very important, because this is something that will require quite a lot of work together with this provisional registration. We'll talk about that in a few slides. So for substances that are already on the market on the Turkish market by the time of publication of this procedures and principles. The lead registrant must be selected. So you have to go through the selection process we'll talk about and be nominated as a lead registrant by end of this year. So this is a big thing, and this applies to essentially all substances on the Turkish market by this 12th of August last week deadline timeline of publication of this. If you are placing a substance on the Turkish market for the first time after this 12th of August 2025, so last week, for example, now, then you must go through the selection process and nominate within 6 months. So now you have a bit more time, but this is a very few cases, I would assume, at the end of the day. So all substances, regardless of the tonnage band, will have to go through this lead registrant nomination by end of this year. So this is something that has changed a bit from some of the draft version or some of the discussions that were undergone earlier this year and end of last year. So and also the lead registrants are selected on a voluntary basis, very important. There at some point there was discussion about just the ministry just appointing something, but that was probably more misconceptions rather than truth per se. But now it is encoded again very clearly, it's voluntary. But if no company volunteers, then the ministry can appoint one company as the lead registrant based on certain criteria such as the highest tonnage band, most data available, company size, etc. And this will be done in cooperation with this Union of Chambers and Commodity Exchanges of Turkey, this TOBB, TOB, we call it TOB. And they will essentially have a dialogue of who should become the lead registrant and select for what, and go through the criteria and make the selection themselves. So unless you wanted to go to this and have this musical chairs of becoming a lead registrant, I strongly suggest you now take the initiative and step up to become the lead on a voluntary basis. This is a strong recommendation. So how does this nomination process work? So this, if you want to nominate yourself as a lead registrant candidate, you need to do it in the KKS system. We'll have a few screenshots in the next pages. We'll go through that quickly, rather quickly, I'd say. And then this KKS will show who are the candidates for lead registrants for lead registrant for this particular substance, so that they can cast their vote. We'll talk about the voting in the next slides. So as part of this nomination, then the lead registrant candidate also needs to provide justifications why it would be a good lead registrant. You can't provide the justifications in the system through the KKS system, but you can send separately an email with this sort of a justification. And this is mentioned in this, again, in this Article 8 of this Procedures and Principles. So you need to do it. It's in the legal text now. And what would make you a good lead registrant are, for example, you have experience. You have this is not your first rodeo pertaining to lead registrations. For example, you worked with the EU REACH lead registration cases. You've done already KKDIK lead registrations before all of this. Like REACHLaw, we've done a lot of these already. I know others have also. But of course, preferably both, because then you have even a broader experience than just on KKDIK, because in KKDIK, for example, the letter of access process and reimbursements and stuff has not really come into play yet. So many companies do not have experience in this unless they have been managing joint submissions under EU REACH, for example. The other good, let's say, indication of a good lead registrant is that you're representing, for example, the EU lead registrant in Turkey, either a subsidiary, for example, of the lead in the EU, or through an only representative. You're a data-rich company, you own your data or have legitimate access to the data needed for this lead registration dossier, so all the endpoints, fisc and tox, ecotox where needed, the more the better. Higher tonnage band, of course, is an indication that you have a higher vested interest in the market in Turkey. Also demonstrating trustworthiness is good, show that you have a long track record, etc., and excel in this type of work. And all of these are good evidence that you are likely a very good lead registrant also. And this should be taken into account then on the other side when the CIF members, pre-CIF members are reviewing and thinking about who to vote for in this through this KKS system, which we'll look at in the next few slides. So in many cases, indeed, the lead registrant will be an only representative. So it's very good to understand. So this only representative should then have these capabilities and experiences here that we see. In many cases, of course, and most, if not all cases, the only representative does not own the data, but their client can. So you should have a look at those in tandem if that is the case. If, for example, an only representative is nominating itself as a lead. So if you look at quickly the screenshots in KKS. So in this pre-CIF section of the KKS system, so if you go there, you can see different substances that you have pre-registered for. So then you select one of those. You can then nominate yourself as a lead registrant. If there is no lead registrant, then this area here will be empty. So in this case, we have a lead registrant nomination in KKS without other candidates. So in this case, you would essentially nominate yourself, and because there are no votes going forward, you would eventually then select this lead registrant declaration button, and you become a lead registrant, after which you are shown here in this box as the lead registrant. And here we can see, for example, REACHLaw as a lead registrant. So this is a real case. So this was a situation where there were no other candidates that are wanting to become the lead registrant. Now we look at another case where the lead registrant voting system, in case of many lead registrant candidates, more than one. So what you would, looking from the previous screenshots, you would then see here the two, in this case, two different candidates. You could also apply yourself if you wanted, but in this case, I'm looking at it from the non-nominating companies perspective, so the potential co-registrant perspective. So in this case, you would then select, in this case, we are selecting this hypothetical Istanbul Chemicals Corporation International as the candidate you prefer, or we prefer, to become the lead registrant. And we would have preferably also reviewed the email that they have sent out with these justifications why they would be a good lead registrant. So you'd select that. And step two would be, you would, once having this selected, you would click vote and you would be done. And you could also see who else has voted for this company in this pre-CIF. And so the process is very simple from a technical perspective, but the voting indeed is done in the KKS system. That is the most important thing you should remember from these four slides. So it's not like only email as we had, for example, in the EU for EU REACH back in the day. So the approval process then from the CIF members side. So once a candidate is proposed, then the CIF members will have 30 days to approve or reject this candidate, lead registrant candidate, in this KKS system. So likely the time starts ticking when a candidate has proposed itself as a lead registrant candidate, and not from when the first vote is cast. But this goes into granularity that we can check later on. So when casting this vote, also in this latest procedures and processes, each SIF member should communicate their positive or negative opinion. This is done in KKS, but they would also provide justifications why they think a lead registrant is suitable for the job, and do this by sending an email to this lead registrant candidate. Because the lead registrant candidate is then collecting this information for the archives, if needed, to be shown later on to the ministry if there are any issues with the nomination process per se. So this is in the legal text. I'm pretty sure most SIF members, pre-SIF members who are voting for a lead registrant candidate will probably not send a lot of emails to this candidate saying how good they are. So, but it's in the legal text in this procedures and principles, Article 8. Interesting also is that if there are no responses by members within this 30-day period, then it's considered that these no responses are actually a positive response. And apparently, albeit this is not mainly exactly clearly stated out in the document, it likely means and applies in cases where there are no votes cast by anyone. Because otherwise, if it then it would make no sense if you also have people or companies casting a vote, and then also the ones who are not casting a vote are positive. I mean, that would be nonsensical. That would be the first who starts the process wins, I guess. Interesting nonetheless, but this is the way we think it is working. The lead registrant is selected by absolute majority vote, not simple, but absolute. So absolute means that it is over 50%. Simple means that any one single candidate who just has the most vote, it can be less than 50 wins. But I think in the invite I may have misspelled that as simple, but it means absolute majority. Very big difference. So you have to have 50%, but this is already better than what we had in some of the drafts where they said, if I recall, 70% or so, which was quite a high percentage. So 50% majority vote. If a lead registrant candidate is not approved, then the process starts again. And this candidate has to withdraw its candidacy, and this is essentially then done by emails in the system. With the members. I guess you can also actually in the system withdraw your candidacy. Now we have to check that. Again, a bit more granularity as I don't have myself access to it. Anyway, so once then this lead registrant has been selected, I call it provisionally at this point because there's still a possibility of it not being selected for the full process, lead registration process. We'll talk about that here. The lead registrant then needs to communicate with the SIF members, pre-SIF members, and provide information about the SIF agreement. Either it can be like a draft SIF agreement for comments, or then you have to itemize, provide full details, full transparency of what the upcoming SIF agreements will contain, and get essentially approval for that from the SIF members, pre-SIF members. And in this procedures and principles document, Article 4 defines the SIF agreement. Well, I call it a SIF agreement. It can have different names. It can be a joint registration agreement, whatnot, but I just call it the SIF agreement because that's usually what it's called. But there it defines in Article 4 this as a comprehensive agreement to be concluded between the lead registrant and the potential registrants, covering all matters related to the fulfillment of joint registration obligations. So indeed, a very comprehensive document, a very similar, I mean, essentially the same type of document we have had for EU REACH purposes. And we've drafted a lot of those here at REACHLaw, for example, over the years. Also information about the data sharing mechanism that's provided typically in this in the SIF agreement, and it should be there. If it's not, that's a bit of a red flag. but then also practical information about tonnage bands to be registered and stuff like that. But the most important part is indeed this this agreement, CF agreement, and all topics related to that, what will be covered. But in practice, highly recommend just sending out the draft CF agreement or a final draft or whatever you want to call it for, like an approval. We can all understand that we cannot go through like a very detailed approval process for this document because it will take ages simply. So therefore, again, once absolute majority have accepted, I call it a vote, but accepted this CF agreement, for example, in this case, among these pre-CF members, then only then the lead registrant can proceed to conclude the CF agreement and start the actual lead registration work. And if we look at these timelines, essentially this means that you should have this done already by end of this year. That's the way I look at it. More details may be up, but it could be enough that you you're in the nomination process. But I would assume that it would be more sensible to also have this part accepted, so that the lead registrant can then start with the actual lead registration work ASAP after this. And again, if absolute majority vote is not achieved, they don't accept half of, or at least half of the, so over half of the attendants don't accept this CF agreement, then you start again. So quite a lot of procedural processes here to keep in mind. So indeed, once everything is accepted, then of course the lead registrant should again notify the pre-CF members that now we're starting with the actual practical joint registration work, and just keep the members always up to date of the developments, especially all these procedural developments and much more, of course. Being a good lead registrant, that is what you would do. Then we have this small issue, or not an issue, but a special case, which, for example, REACHLaw is a candidate of, or we have these cases, let's put it this way. So in case you've already nominated a lead registrant by the publication, by the time this was published, this procedures and principles, so by 12th of August last week, this year, 2025, but the lead registration dossier has not been submitted, then the text says that the lead registration selection may have to be redone if necessary. It's very cryptic, this if necessary. I would assume this would mean, and this is a bit of speculation on my part, but I would assume it means that if there were some irregularities or the selection process was not done properly to begin with, then there could be situations when the lead registrant status would be contested, and then you would do this nomination process again. Because we know of cases where the lead registrant or some actors have just grabbed the lead registrant position without actually having any formal voting or anything. So these cases would be then up for debate, up for contestant, and probably would fall under this if necessary clause in this under this Article 8 of this procedures and principles pertaining to selection of the lead registrants. Okay, that concludes the lead registrant selection part. Quite a lot of hoops. Now the next favorite thing, or maybe the most favorite thing, is this provisional registration that people were already hoping that it would be gone in this final version, but it is not. So indeed, this provisional registration is a requirement for both lead registrants and co-registrants in cases where the lead dossier is not submitted by end of March next year, 2026. If you are now able to submit your lead dossier by this deadline, by this timeline, then you are not eligible, or you're not susceptible, let's put it this way, for this provisional registration. You do not have to do it. But today, and this has been a bit back and forth the last couple of days, is that the prevailing understanding today is that this provisional registration requirement then applies to all substances at any registration deadline at any tonnage band where the lead has not submitted the lead dossier by 31st of March 2026. So this will be bulk of all substances will fall into this category. So I would say 99% of now this is of course winging it, but like a very high percentage of all substances subject to registration under KKDIK will have to go through this provisional registration process. By the lead registrant, they have to submit certain information by the same deadline or timeline deadline, in this case 31st of March 26 next year, containing information in this annex of this procedures and principles, annex 1. You can see it here on the side. So the lead registrant has to submit all of this information: substance identification information, classification labeling information, manufacturer use exposure information, physical chemical properties information, and guidance of safe use. So this has to be submitted by 31st of March next year. And as you can see, for example, all of these points except number 4 is something that, or maybe 2 to some degree, 2 and 4 could be something that are, 4 in particular, would be subject to a letter of access. So what this in practice means is that you will likely, depending on how the lead registrant set things up, you will actually have to also buy a smaller letter of access for the provisional registration as a co-registrant, and you have to submit this information as by end of September 2026. So you have to submit all the information except these 2, 4, and 5. So you need to provide substance identification information, so analytical information, etc., and manufacturing use exposure information, as you can see here, estimated quantity, sites, and so forth. Lead is also submitting this, but you do not have to provide information on the classification, labeling, physical chemical properties, guidance of safe use, because this is provided by the lead registrant, and that's why you would have to have a letter of access for these endpoints I would say in several cases, if not all. This is quite new information, so the situation is developing, but just be ready to have like a provisional letter of access also needed for the co-registrants by this their provisional registration timeline. So indeed, this also has to be, these provisional registrations have to be prepared by this chemical assessment experts, KDU, so they have to sign off on it. So not just anyone can do this. And what also applies are the registration fees. So you will at this point in time be paying the registration fees according to what we looked at in the previous slides. So depending on the tonnage band of substance and if it's an intermediate or full substance, likely a full substance. It is not entirely clear, will you have to pay this again when you register again, but that remains to be determined. I would assume you will, but we will see how things pan out over the coming 12 months or so. So that is the provisional registration, very condensedly presented in this one slide. Then some miscellaneous topics from these procedures and principles I wanted to highlight, not of so much interest, but good to know nonetheless. So they are also implementing this, they call it implementing provisions and monitoring, this Article 14. where it essentially says that guidance documents published by the ministry shall also be taken into account when, for example, preparing dossiers or registrations, etc. So what that means is that now we have a legal reference that ties in guidance documents provided by the authorities into the legal framework of the KKDIK regulation. So you need to, again, now follow the guidances. And of course, this also opens up the possibility that you could put almost anything in the guidance and you have to follow it. I'm sure that this will not be the case, but I guess you could do that. So very interesting, I would say. So good to keep in mind. Also, there are provisions on registration, updating the registration dossiers. So now we have this 3 months type of a thing that we have in the EU, for example. We have different months depending on the type of update, but in this case, it says that if you need to update the registration, then you have to update this within 3 months from the date that the update is required. So now you have a hard deadline again to update. And if you for whatever reason cannot update, then you also have to contact the ministry in writing and ask for extension and so forth. Go through the hoops. And indeed, we talked about this already, but entry into force specified in Article 18 of this Procedures and Principles says that it is entering into force on the date of its publication. So in this case, 12th of August last week. So it is already in force. So there's no ifs, ands, or buts. It is in force. And now we have to deal with it. So if you look at the deadline summary, just want to put everything in, try to put everything in one slide. I hope it's correct. Anyway, so indeed, first deadline, hard deadline coming up is the pre-registration deadline. You can do late pre-registrations if you're placing these substances on the market for the first time after end of October. But these are very specific cases, of course. Most of you are already placing these substances on the market, so you have a hard deadline for the pre-registrations of end of October 2025. So just in 72 days, if I count this correctly. Then the next deadline per se, according to these procedure principles, is the lead registrants must be appointed by end of this year for all substances, for all joint submissions, any tonnage band, all deadlines, the same deadline for appointing this lead registrant. Then the next one is the provisional registration for lead registrants, and this is done by 31st of March next year, 2026, unless you have submitted your lead before that, lead dossier before that. And in cases where the lead has not submitted the lead dossier by 31st of March 26, then also these co-registrants have to submit their provisional registration by 30th of September 2026. And then we already have the first registration deadline end of the year, so 31st of December 2026 coming up for these higher tonnage band CMRs and very toxic to aquatic organisms, substances at 100 tons or more. CMRs was 1 ton or more. So indeed, a lot of things happening here in the span of like 1 year, 1.5 years. So now it's time to get active on this. Things are happening. We've been waiting for this, maybe hoping some were hoping for this to be scrapped. Swiss model, yada yada yada. That's in the bin. Now we have to face facts, the realities, and start working on this. No more excuses. So indeed, there are some interpretations on these procedures and principles circulating. More information will become available. For example, in 2 weeks, based on our understanding, there will be some sort of a workshop held by the authorities, likely in Ankara, in Turkey, aimed for the industry associations to participate in, and they will be covering these procedures and processes. And of course, Turkish Chemicals Industry Association, TKSD, will be there to voice their questions and information, and they will be attending the workshop. And after the workshop, of course, we will know more. It is unclear if other than industry associations will be able to attend this, but probably not. But in any case, as we work closely with the TKSE, we're a member, we can of course get access to information in this workshop. And also just wanted to highlight that TKSE is very active on this topic. So they will also be likely organizing more sessions, online webinars, sessions, events, etc. very soon. So stay tuned. If you are not a member, then maybe that it's good to become a member. This is not a plug, but it is just a good source of information. Also for REACHLaw, for example, we found it very informative. I said this is not a plug. I'm not a sponsor. I'm not getting any sponsors, any money for this, but I just say that it's a good source of information and good association. So anyway, we are of course ourselves following the developments very closely, and we will expect more details from the authorities soon. However, very important, you can already act based on this procedures and principles document and what you've seen in this presentation, the webinar, and you should already start acting because time is very short. Make sure you have pre-registered all your substances that you need to, find a lead, get this lead nominated and selected by end of this year. That's already a lot to do, I can tell you. And in short succession, you then have to also start preparing for this provisional registration as a lead by end of March. So there's a lot happening now. And why, I know that someone would ask, why do these companies who have a later registration deadline, for example, even as a lead registrar, why do they have to submit this provisional registration by end of March next year? And the reason is that the authorities want the whole registration process to be kick-started for all substances. So this really makes it, now we have a clear deadline for doing stuff, even for those later registrations. So you have to even get organized with these later registrations. No more excuses. Now it's up for industry and us to take care of this work and do it by the applicable deadlines. So let's look at some what does it mean for industry and some actions in brief before going to conclusions and Q&As. And at the risk of sounding slightly theatrical, I would say the honeymoon is over. It's time to get back to KKDIK registration work, and there's very little time to waste. I mean, there's no time to waste. Time is ticking, time is up. Now we need to get cracking on this. As consultants, as industry, as actors on the Turkish market, placing chemicals on the Turkish market, manufacturing chemicals in Turkey, and so forth. We need to get organized. Time's up. For those of you who know the reference in the picture, kudos to you, science nerds, or science fiction nerds, I would say. Okay, so just wanted to highlight a few things. Pre-registration, for example, what happens if you do not pre-register by this deadline, end of October this year? What if you are not eligible for late pre-registration, of course. Let's say you have not pre-registered, then there's no data, no market clause applies to you. What this means is that you would likely have to submit an inquiry for the substance. This inquiry is methodology for submitting an inquiry dossier is not available in the KKS system today. This is the menu today. So you have pre-CF, so where you submit pre-registrations, registrations, CLP notifications, people notifications, alternative name requests, and the harmonious classification dossiers. These are what are available today, these 6. But we have seen in the industry, oh, sorry, not industry, but in the authority slides and presentation that they have this inquiry, amongst others, inquiry enabled. So at some point, you will have an additional button to submit an inquiry through this system. Of course, now, if you now forget to pre-register by this timeline, and let's say an inquiry is needed, you submit an inquiry, it's available. The problem is that likely there is no joint registration dossier yet available. So what that means is that an inquiry is not enough. Essentially, you have to have a registration in place already, together with the inquiry, before you can start placing the substance on the market. If we go according to the most stringent interpretation, which would, for example, apply in the EU. So of course, if there's no joint submission, you can't join any joint submission and get access to the data to submit your own registration following the inquiry, and you would be essentially sidelined until this joint submission is available. How this works in practice, we'll figure it out. But if our recommendation, if you forget, first recommendation is don't forget. Second is, if for whatever reason you miss, just then contact the ministry and see what you can do. The KKS system is undergoing updates as we speak, and it is very likely that this dossier submission feature, which has been frozen for how many months? 60 months, over a year, it will now become active again in the next 2 weeks or so. So what this means is that you can now again start submitting your dossiers. You were already able to prepare these dossiers in KKS. You could do lead, co-registration, etc., but you could not submit them. But now, when this becomes active again within a few weeks, you can do so. So things are happening at a quick succession, I would say. So indeed, if there is currently no lead registrant, and this is still a lot of substance, majority of the substances do not have a lead registrant. Time to act is now. You must have a lead registrant to be able to submit the joint submission and take part in a joint submission. So if there's no lead, you're out of luck, you can't register, you have to withdraw from the Turkish market or just supply under 1,000 kilograms annually, which is probably not a lot of business unless you're in the how do you say these precious metals, being a bit of a side business, I guess. Anyway, you should now make every effort to find a lead registrant, and better yet, you should become the lead registrant. I still see this, that companies are apprehensive of taking the lead registrant role themselves because they think it is something that is overwhelming, very difficult, very costly, this and that. But it is not, I can tell you. We work with hundreds of lead registration cases. We have a lot of experience with this. I think others have also. So, and it is an established process. Data is available. If data is not available, that's a problem. But data is available. So it is not that much of a deal. I mean, it is big per se, but it is nothing compared with a lead registration dossier under EU REACH, for example, or K-REACH or whatever. So now, just get it done. Act now. Take the lead registrant position, and of course you have to be elected to become a lead registrant, selected. But still, it is better than the ministry coming and picking someone at more or less random, I guess, who, according to them, fills certain criteria, but is still reluctant to become a lead registrant. It's better to become the lead registrant and hate becoming a lead registrant the least. So if you are selected by the authorities, it could be that they are selecting the company who hates becoming a lead registrant the most. Something to consider. And if you don't have budget for this year now, especially if in cases where you want to become a lead registrant, then you need to escalate this in your organization and get the funding secured as soon as possible, because this will cost some money to get done. But as a lead, much of the work that you're doing, most of the work, is something that is shareable between the between all the registrants of the same joint solution, provided there are other registrants. So indeed, time is ticking. The registration actions are not waiting around for you to get organized. So now just get it done, get the money where need be. Put simply, make sure you have pre-registered all substances you placed on the Turkish market at 1 ton or more by end of October this year. Nominate yourself as a lead registrant for substances that do not have a lead registrant yet. And you need to do this well before end of this year, because they need to go through the process of being selected by end of this year, as we discussed. So, conclusions, at the risk of sounding repetitive, indeed, this procedures and principles document that was published last week, it is now in force. It aims to clarify parts of the KKDIK registration process, which it does, but it also adds additional complexities, for example, this provisional registration. So the deadlines are indeed pre-registration end of October this year, lead registrant selection end of this year, provisional registrations for leads end of March 2026 next year, and for co-registrants end of September next year. There will be more information coming out from the authorities. They were having these events, probably maybe something additional documentation published, but still you can already act on what you know now as of today, based on, for example, this webinar and the document itself, of course. So make sure you have pre-registered these substances by end of October and have found a lead registrant selected by end of this year. And of course, REACHLaw, we're keenly following all the developments, so also stay tuned for more from REACHLaw. We will be publishing newsletters, LinkedIn posts, and having webinars, so please subscribe to all of our channels, LinkedIn, newsletters, and YouTube, to be informed on all of these developments through REACHLaw. So indeed, and also if you need help with KKDIK compliance, with this lead registration process, domination, as an OR, or if you don't need an OR but you operate already in Turkey, we're of course very happy to help. So feel free to contact us, ask for quotation or a meeting, Teams meeting, to discuss this in more detail. We're happy to accommodate that. So with that, going to the Q&A finally, and we're over time as usual, but yeah, such is REACHLaw webinars. Anyway, coming back to the Q&As, so indeed we have different questions here. I can see that there are questions coming in through the chat. We'll deal with those after we have covered these questions that have been pre-submitted. So let me just get organized slightly here so I have them all. So indeed we got a number of questions submitted before the webinar, but I try to consolidate questions and put some questions that are clearly already covered in this webinar. Did not put them in this list, so we have 12 here, and then I can see a number of questions in the chat. So we'll see how far we get. But if you have to leave, that's fine. You can always come back to the recording later on. But if you want to stay, thank you very much. We appreciate that a lot. All right, so I also invite Sibel to join back into the Q&A. Hello, Sibel, are you there?
Hello, thank you, yes.
Hello, hello, yeah, very good. It's almost like the Eurovision here, but that's not quite. Okay, slightly duller subject, I think. Anyway, question number 1, does the new publication affect pre-registration? If so, do they all alter tonnage threshold provisions? So, well, as you saw from the slides, indeed, this does affect pre-registration. Now we have a hard deadline, end of October. So, and it's for all substances that are subject to registration, regardless of the tonnage band or registration deadline. So yes, absolutely affecting. I'm going through this quite quickly. Just feel free, Sibel, to chime in and add additional value to these answers if you think it is needed.
Yes, sure.
So, question 2: why must lead and co-registrants submit the provisional registration in 2026, although the latest deadlines are in 2030? And this I already covered, but indeed, the ministry authorities now want the registration process to kickstart, hard boot, reboot, whatever you want to call it, for all substances now, not so that certain companies for certain substances later deadlines can still say, okay, well, we can wait, we don't blah blah, and then they forget everything, and it's the whole problem again coming back closer to the next deadline. So now everything happens at the same time, and everything's kick-started at the same time, and it makes sense. We have been, how do you say, we've been complacent for far too long, and for reason, because we've not been able to do much, because there's not, the KKS system has not allowed for submissions, etc., and there's been this veil of uncertainty. Will there be something other model, and etc.? Will there be these procedures and principles, and what will there be? No any registration at all? But now the veil has been lifted. Everything is crystal clear. We have the same deadlines for all substances. Now it's time to act. Sibel, do you have anything to add to my preach?
No, it's okay, Freddy. I will be just jumping if anything. Thanks.
Yeah, good. Will the registration deadlines be postponed? Again, do you expect registration to occur next year? How many lead registrants nominated? Well, we looked at the nominations, but 372 or something like that. It was in the slides. And no, we're not expecting the registration deadlines to be postponed. They've been postponed once. Now we have enshrined in legal text this procedures and principles with additional deadlines, all culminating into these actual registration deadlines that were already postponed once. So we are not expecting any postponements, and neither should you. Question 4: is the Turkish registration system still down? What is the current status? Are there any recent updates to the system? So this I already covered. So yes, in 2 weeks, likely it will be open for submissions. So they're working on it. Probably there will be additional features coming up also as we go forward, like, for example, maybe this inquiry, etc., to be determined. But submissions will be open back in business very soon. What if you are the only registrant in the SIF, but not yet sure you want to register by the deadline? Do you need to apply as a lead registrant anyway? So yeah, I mean, if you're not sure, that means that you cannot say that you will not place the substance on the Turkish market. So I mean, your options are to lead register in advance and then have the option to place your substances on the Turkish market at any time, or then you hold back and lead register when you find a market later on. But that could mean that if, depending on when the deadline is, that you may have to have the lead registration in place before you can start placing substances on the market. So it's really a business decision for you. If you're on the fences, I would rather have options open than option closed. So I would go ahead with the lead registration anyway, because it's not that big of a deal. Just wanted to highlight that again. REACHLaw, question number 6. REACHLaw is lead registrant for carbon black. When do you plan to provide letter of access for the KKDIK registration? Discussing with the team, at the latest early 2026, you will have the LOAs available for this carbon black. What are the main differences with what was previously in place? Well, we've discussed these. Now we have this provisional registration. We have deadlines for lead registrant nomination and having a lead registrant selected, not the nomination, but the selection. And then we have pre-registration deadlines. And also these tie-ins with guidance and stuff that we discussed. So quite a lot of like practical deadlines being introduced with this procedures and principles document, which is, I think, good. because now we have clear timelines to work with, and we know what to do and how to do it, and now we know by when we should have it done. As we have this, is there a possibility to extend the registration deadline in the future? Will the registration dates be postponed, pushed back as proposed for UK registration dates, for example, 3 years? So again, coming back to the previous question, I should have combined this with that one. So we're not expecting these, and neither should you. Please explain the concept of provisional registration and what happens after a lead registrant is subsequently appointed. I think this has been now covered in great detail in this presentation, so I invite you to just scroll back and listen to those parts again. For substances registered in 2023, what will be required? So as discussed, this provisional registration is not applicable if you submitted the lead registration dossier. So, but of course the registration timelines still apply, and in these cases, of course, you have been appointed a lead registrant. You may have already the CIF agreement in place. If not, then you should work with that according to the requirements of these procedures and principles. And yeah, that's about it. And then, of course, chase your members, your whomever who needs to pre-register, just to make sure that they are also pre-registering by the deadline, albeit that may not be your responsibility, of course. Then a question: can the lead registrant submit their full dossier after 31st of March next year? So yes, and this will be, I assume, the most prevailing case, because most will not have time to submit it before this date, which is the cutoff for this requirement for provisional registration. So yeah, absolutely, but you have to, of course, submit it before the applicable registration deadline, and a good time before the applicable registration deadline, so that the co-registrars have time to also join in to this joint submission. And the final question pre-submitted, well, there were more, but we skipped some of them for repetitive purposes. Is late pre-registration for KKDIK still possible? Under which circumstances? So indeed, if you're placing a substance on the Turkish market for the first time after October 31st, then you're eligible for late pre-registration, and you should do this late pre-registration within 30 days from first time placing this substance on the Turkish market, as we discussed. So rewatch those segments on YouTube if you need to. All right, so let's have a few questions here from the chat. Please allow a few seconds to just have a look. Have we adequately covered this already, or do we need to rehash something? So give me a few seconds here. Yeah, there's questions about provisional registration. This was submitted before I came to that section, so I invite you to have a look at that. Questions about the KKS system being reopened. We talked about that in 2 weeks. Hope it's not the same 2 weeks as some political figures are always saying. If you know, you know. With regards to the lead registrant appointment by the authorities, what if the designated lead registrant finally does not intend to register? Well, that would, yeah, that's a bit of an issue. That as I mentioned, maybe you have a situation where the authorities appoint the company who hates becoming a lead the most, and then they just don't deliver, or they say that they work on it, and then no, we don't. Then of course they would likely find another alternative. Hopefully by that time, that CIF would have figured out that, okay, maybe it's better to have a volunteer, so the one who hates it the least becomes the lead, and then goes through this nomination process. And then if the previous lead already have done something, they have to then share this information like data, etc., with this new lead registrant. So there is a process in that. I did not cover this in the document in this presentation because it was a bit of a fringe, but there is a process for that. So better, summa summarum, just try to volunteer as a lead. I think you will just, that will save a lot of trouble in the future. And of course, also in these procedures and principles, there are provisions for cases where you are not, you don't have the data available to submit the registration by the timeline. So there are provisions in place that you can then contact the authorities and ask for extensions and so forth. And if I now recall correctly, they could provide a maximum of 2 years additional times to then comply with these specific requirements. So this was a bit like, yeah, go ahead, Sibel.
Yes, I just to say correct, Frederik, you are remembering correct for extension is possible.
Thank you, Sibel. And this is a bit like the directors contact group for those of you who lived through that for EU Reach back in the day. So you could contact them and say that, hey, we have a deadline coming up, but we don't have all the data available to submit to fulfill all the requirements. So you were given like an additional timeline to, you submitted what you had, and then you got a timeline for updating that dossier with the full requirement. So this is a bit the same that they are providing in this document. Let's see. Yeah, about questions about the registration deadlines, postpone, we talked about that. Is the pre-registration required if intention is to import less than 1 ton per year? So no, just in this case, I would just like you to take into account possibility of expanding your business. If you know that you will never exceed the 1 ton threshold, then I mean, you do not have to pre-register. You don't have to register. But maybe it would be good to, just in case, pre-register so that you have the option and then eventually go through this provisional registration. Just have the options open to place the substance on the market until you have your registration come up. For example, end of 2030. So it's a business decision. Many of our clients have as a cutoff like 600 or 700 kilograms a year, because if it's over that, there's a chance that it will exceed the 1 ton threshold in the coming year or years. So it's up to you, but legally speaking, no, it's not required. You talked about submissions of registration. Is the MOE EU CC ministry legally capable of appointing a lead? Yes. What if a company refuses? Well, that's if everyone refuses. What then? I hope it doesn't come to that. I guess they would say then that, well, they would ask, are you going to place this substance on the market in Turkey in the future after the registration deadline? If you say yes, then they would say, well, now you register. Then you have the option of I guess, just ceasing import. Maybe at that point you could not even do that anymore. That's I'm not a lawyer, so I can't say what the let's say, do they have the mandate to do that? But I think with this document they could have the mandate, or they could interpret that as having the mandate. So again, just try to find someone who wants to actually be a lead or hates it the least, at least. Let's see. Can several lead registrants nominate themselves at the same time? So yes, for the same substance. Well, they're not lead registrants. They are lead registrant nominees. They only become lead registrant once they're selected to become a lead, as we discussed. Then there was a question on when a lead registrant nominates himself as a candidate KKS, how will the other CF members be informed? Well, they will see in KKS that you have nominated yourself, but but they will not receive anything else. So you will have to provide, on top of what they see in the KKS, you will then have to send separately by email these justifications why you think you are a good lead registrant. If there are any changes coming to the KKS system, it could be that you could provide these justifications there also, but that at the moment it is not possible. So we'll see if they develop that further. Yeah, then we have this lead registrant were elected before publication on principles, procedures and principles. Is the need to have again an approval process. So indeed, this is the if necessary thingy. So I invite you to have a look at the where we discussed this. So if you conducted or did not conduct the proper selection process way back when, then I suggest you do it properly now, because you could be contested. I see that as being the if necessary thing. It is a bit vague, but that could be one of the scenarios. Then there was a question about, does the CIF agreement need to be approved and signed before 31st of December 2025 or prior to lead provisional registration? So that is not explicitly mentioned, and Sibel, feel free to chime in, but it's not explicitly mentioned in this procedures and principles. It just says that you have to have it agreed. So that I would think that means that you have it agreed so that everyone agrees that this is the context of the CIF agreement. To be absolutely sure, you would want to have it signed, but I'm not exactly sure it's needed. But at least you have to approved and being able to document this, and it must be the majority of the members. So 51% or over 50%, in other words.
I can comment that.
Yeah.
Just it needs to be voted but not signed. But once you just join the provisional registration, then yes. Once joined, yes.
Yeah. Thank you, Sibel, for that. Last question. What is the disadvantage of provisional registration? Well, I mean, is additional work a disadvantage? Depends. Of course, is it a disadvantage that you have to do the provisional registration now for substances that you have to lead register by end of 2030? I guess you could say it's an inconvenience. I don't know if it's a disadvantage. So it depends on who you are. I wouldn't call it a disadvantage. I think actually this finally is a good thing, because now we have to get cracking. Now we have to get things done, and it is clear, no more daydreaming, no more honeymooning. Now we just get it done, be done with, and life goes on. That's it. Sibel, that was concluded the questions. Do you have any final notes before we end this webinar?
Thank you, Frederik. I think you well covered. Then, so to say that the idea is to move. This is what we see from the text as a last message. Thank you.
Good. Okay, very good. Just wanted to highlight that, of course, feel free to reach out to REACHLaw for support. We're happy to help, but also we are attending ChemCon Europe in Venice, Italy on the 27th to 31st of October. So just at the brink of the pre-registration deadline for KKDIK. So if you are there, come and say hello. If you haven't thought about attending, maybe you could attend and meet us there. There will be good discussions and presentations. And I will, for example, talk about Ukraine Reach, and colleague will talk about India BIS, but there will be discussions about Turkey KKDIK for sure a lot. So with that, thank you very much for attending this webinar. Thank you, Sibel. So with that, thank you also for listening, and for those of you who have stayed until the end. And I know I did not cover all the questions. If you have additional questions, feel free to reach out to Sibel or myself. You see the contact details on the screen, and you can also find our contact details on our website, reachlaw.fi. So thank you very much, and start working with KKDIK, and we're happy to help. And with that, goodbye and good luck, and see you next time. Thank you.
Bye-bye.